Good morning, ladies and gentlemen. My name is Maxim Burak. I am partner at GRATA, head of corporate practice at GRATA Novelty office in Kazakhstan. And today we're gonna introduce you a webinar concerning the changes in corporate legislation and its applications in various jurisdictions of GRATA International presence. Today within this session, we're gonna cover Georgia, Turkey, and Moldova. Let me please introduce today's speakers. Those are in the order as they will speak. Mr. Irakli Kordzakhia, he is managing partner at GRATA Georgia, Tbilisi. Mr. Ali Ceylan, a senior partner at GRATA Turkey, Istanbul, and Ms. Diana Lupu, associate at GRATA Moldova, Chisinau. So if Irakli, you are ready, I think we're going to proceed with this. And Mr. Irakli Kordzakhia is going to speak about upcoming amendments to Georgia law on entrepreneurs. So, Mr. Kordzakhia, please proceed.
Thank you for introducing me. How much time I have?
It is basically about 20 minutes.
20 minutes. Thank you very much. I will not have a bullet point PowerPoint presentation, as the law is in the form of draft, and it is still discussed in the parliament, and we expect that new law on entrepreneurs will adopt it in the form proposed by Minister of Justice, but still there's some discussion going on. Yesterday when Parliament has started procedures to adopt this new law on entrepreneurs. I want to give you some background to why there was need to adopt a new law on entrepreneurs in Georgia, because it's quite significant legislative effort. We had the existing law on entrepreneurs from 1994, so already almost 20 years. It was adopted pretty much after German laws, as you know, GmbH-Gesetz, AG-Gesetz. So it was a reception of German law, and it was quite detailed. Lot of imperative provisions. Even the balance sheet, structure of balance sheet was regulated there. But after coming to the government, right-wing party, national party, there was major reforms were made to the existing law in 2008, and many regulations were just deleted from the law. So, just for example, provisions on the part where it is LLC, limited liability company, is regulated, consist of only 5 articles. Of course, there are some general articles regulating directors, General Assembly, rights of partners, rights of shareholders, but still law is really lean structured right now. It was explained because of this, because of the idea of giving more freedom to parties to regulate their rights and obligations in the charters or shareholders agreements. So what was left in the law, most of the provisions are right now are dispositive provisions, and parties can change them in the charter. But in fact, most of the parties, most of the investors or shareholders, entrepreneurs, cannot afford to hire experienced lawyers, corporate lawyers, like distinguished panelists here. So they were choosing to adopt very lean charters, which were lacking many provisions, which happens in corporate life on enterprise, and it was leading to very expensive and complicated disputes in courts, Georgia, because which created sense of uncertainty and lack of regulation, lack of uniform regulation, because different courts in different regions cannot can adopt other different case law, different decisions, and not all cases are coming to Supreme Court of Georgia for uniform practice. So even now, among lawyers, we are discussing, can a shareholder be expelled from limited liability company or cannot? Under which circumstances shareholder can expelled? Can shareholder withdraw from the company? I mean, limited liability company, which is very, you will be not surprised that it is the most common form of entrepreneur in Georgia. So, so many issues were not insufficiently regulated, even by court practice. In 2013, the major initiative reform was initiated. Is 7 year already, or 8 year from now. So for 8 years, we are working on this new law and on entrepreneurs. So it was assisted by United States Agency for International Development and also German institution to Zusammenarbeit, GIZ. In addition, we already, Georgia, as you know, Georgia signed association agreement with European Union. We had, under this association agreement, we have obligation to harmonize our corporate law with EU directives. Mainly, it is a directive from, there are many directives regulating corporate issues, but mainly this is a codified directive from 2017 /1132. So before proceeding, before choosing what is better, amend the existing law or draft new law, the regulatory impact assessment was made in 2017. So under this regulatory impact assessment, it became obvious that to adopt new law will be quite expensive. It was cheaper to amend existing law because of changing all software, registration software, educating, training lawyers, and make obligation to bring their charters in company charters in conformity of new law, and many other pieces which can be evaluated in money. But decision to adopt new law was still made because it was in the long run. It was creating more clear structure, regulatory structure to entrepreneurs and foreign investors willing to invest in Georgia. So, what was the problems of existing? What is the problem of the existing company law? They were in the regulatory impact assessment. They were identified as lack of regulation related to withdrawal from the company of the by shareholder, lack of regulating conflict of interests, corporate governance issues related with the corporate governance, best practice in corporate governance, and problems related to liquidation of companies. So it was obvious by the survey conducted between among lawyers, business associations, investment companies, state agencies, and civil sector. So, coming from the fact that existing law was not sufficient, and Georgia had obligation to make legislation in conformity with EU directives. There's a number of directives regulating transparency of registration data, capital preservation, mergers and acquisitions, regulating sole shareholder companies, and yeah, as I already mentioned, most of the directives were codified in 2017 directive, which was main source of law piece, which was used by the new drafters of new law. There was, as I already mentioned, existing law contained a majority of dispository norms, which allowed parties, shareholders, to agree on otherwise. And sometimes these agreements was detrimental to creditors, minority shareholders, or third parties. So this issue, what regulation has to be dispository, and what provisions has to be used by default, and what provisions have to be imperative, was resolved finally in the new law draft. It gives flexibility to shareholders of limited liability companies and other companies to regulate their relations between them otherwise, if they want, unless this it affects third parties. So if it means, usually it means creditors. If parties are enabled, shareholders are enabled to hire experienced lawyer, as they can just rely on default provisions of the new law draft, which will eventually become a new law, which solves problem of lack of regulation, which will guide courts in Georgia how to resolve any future possible disputes. In contrary to dispository regulation in limited liability companies and joint stock companies, majority of the norms are imperative. So party shareholders cannot change them in the charter unless law specially provides this opportunity, this right to change specific provision in the charter. So main difference between limited liability company and other types of companies and joint stock companies, limited liability companies have dispository. The default regulation in the law can be altered by shareholders unless they affect third parties, creditors, and vice versa. In joint stock companies, all provisions are imperative. They cannot be altered, amended, unless law specially provides this possibility to parties. Another novelty.
Irakli, I'm really sorry, but we are about 2 minutes behind the schedule.
Okay,
do you think you can take
2 minutes? Yeah. It's additional novelty of this law is that the Minister of Justice will approve standard forms of charters, which can be used by small and medium-sized entrepreneurs. It is British practice to have these charters in place. Parties can change these charters through shareholders agreement, provide different types of regulation, but it will be cost efficient if and I'm sure majority shareholders, majority investors, small and medium-sized investors will use these standard forms of the charters of joint stock, especially in limited liability companies. Forms of the organization forms are remained unchanged. The new law provides withdrawal of the shareholder, expulsion of shareholders, and also restrictions to allocate dividends in case the money and property has to be used for the interest of creditors to avoid any insolvency of the company. So the new law, we are expecting that new law will be adopted in a 1 to 1 month period, maximum 2, maybe up to 2 months by Parliament, and it will provide clear structure, and the companies will have 2 years to harmonize their charter and their structure to the new law, and it will bring more transparency and less court disputes in Georgia, corporate court disputes in Georgia. Please feel free to ask any questions in English or in Russian, maybe after in the questions and answer session. Thank you.
Many thanks, Irakli. I would like to ask our attenders to direct their questions into the chat. I guess that would be the most efficient way, because after the speakers are finished, we will have a Q&A session where all of your questions can be addressed. But please do not hesitate to write those into the chat. Do not forget anything you wish to ask. So our next speaker is Mr. Ali Ceylan, Senior Partner at GRATA Turkey, Istanbul office. He will tell us about changes in Turkish legislation aimed at dealing with these challenging COVID-19 times and its economic effects. So, Mr. Ceylan, please proceed.
Thank you, Maxim. Once again, good morning to everyone. I'll go through a presentation that I prepared. I will be mostly talking about the changes that the Turkish government implemented in order to protect the Turkish economy against the effects of COVID-19. First of all, I would like to start with the negative effects. As you know, the whole world's economy is affected from COVID-19, which also shows in these numbers on your screen, because like unemployment rate, youth employment rate, inflation, interest rates, all these numbers increased. These are pretty high numbers in the last decade or two. So the government felt a need to intervene with the amendments to the certain legislation in Turkey. As you will see, one of the other consequences of these negative numbers was, Turkish Central Bank.
Mr. Chilan, I apologize for interrupting you. Do you think it would be possible to have this presentation on the full screen and for you to list the slides? Because it seems that on our screens we only see the first slide without getting it listed.
Oh, sorry, you don't see my slide now?
I see. We see only the first one and these schematic view, but not the full screen presentation. If you have one.
How is it now?
Yeah. Now it's great. Now it's great. Thank you.
So one final note about this page of the presentation is because the government need to make financial support, as well as because the foreign currency rates, Turkish lira lost a lot of value against Turkish foreign currencies. So they had to spend the Turkish Central Bank reserves. These are the main problems that the Turkish economy faced. So what did the government do to protect the Turkish economy? The tax restructuring is because there was shutdowns, there was full shutdowns, partial shutdowns. Most of the retailer shops, restaurants, like daily life economic players had to be closed. Even today, as of this day, for instance, restaurants are still closed in Turkey. They can only serve delivery services. That's why the government delayed the payments of taxes, restructured the outstanding tax debts. For instance, they brought installments without interest, that kind of support. They decreased the VAT rates in many sectors, like education, like food and beverage again. The idea was to decrease the cost, the tax cost and social security premium cost of the employers in Turkey. So the government also opened many channels for comparatively, respectively cheaper rated loans to the companies, for small and medium-sized companies, for big companies, for individuals also. And Turkey is an important tourist attraction country. And because of these negative effects of COVID-19, the government had to support the tourism sector as well. The VAT rates again decreased. If you have been to Turkey before, Turkey shores, coasts, you will see like these big hotels, like full service hotels. Most of these hotels are built on government-owned lands. And they pay rent to the relevant ministries, government agencies. They also deferred the payments of these rental payments. They canceled the annual fees, etc. They supported the tourism sector. Furthermore, they now again, as of today, you have seen in the beginning, the unemployment rates are pretty high, and So what the government did, brought these solutions, as you will see. Now, as of today, in Turkey, the employers cannot terminate the employees' employment agreement unless there is a justified ground. But justified grounds are limited. Justified grounds are like issues like, your employee steals from you, or your employee had a fight in the company, that kind of justified reasons. For instance, you cannot fire someone due to low performance, for instance. So they are trying to keep the unemployment numbers in control. The government also gave financial support. Unpaid leave is only applicable if the employer and the employee agrees on it. But now the government gave this discretion to the employers to send the employee on an unpaid leave, and the government pays, and normally, because it's unpaid, the government pays a certain amount of money to the employee who has been sent on unpaid leave. And we have this short working allowance now because of the business volume went down. Some companies, in Turkey, regular weekly working hours is 45 hours. For instance, some companies started to work partially, let's say 30 hours, 20 hours. So what the government did, government supported them by making payments to the employees and also decreasing the social security premiums. So it was a support for both sides, on employer and employee. They also brought this regulation on remote working, again, as a measure to COVID-19. So despite these attempts to resolve the matter, there are some bad news, I would call, for employees. As you will see from the screen, the corporate tax rate is increased. Normally it was 20% in Turkey for a long time, but first increased in 2018, which at that time the government declared that it was a temporary change. But now for this year, this rate will apply as 25%. For 2022, it will continue as 23%. Some other taxes also were increased, which I did not mention here. They were mostly for to prevent import into Turkey, like computers, mobile phones, cars manufactured outside Turkey. They increased the taxes on these items too, so to have less import into Turkey. So what this whole thing resulted, now in Turkey, because of the interest rates are high, the financing needed by the companies is really expensive, because Turkish lira interest rate is high. Before, I would say during good times, the companies were mostly borrowing money in foreign currency like USD, like Euro, because the currency was stable, it wasn't increasing too much, and the interest rates on, let's say, US dollar and Euro was lower, much lower compared to Turkish lira. But now this system doesn't work anymore for the reasons I explained before. But this also brings an opportunity for investors. What happens now? The companies are very cheap. For investors who has cash, I would say a company that you would not be able to buy for a price, let's say 2 years ago, today you can negotiate that, and it happens. And what happened is because the companies need cash and the conventional ways for financing is now expensive, what happened is like the funds and IPOs increased very much, which you will see in my coming slides. As you see, normally you would expect in a bad economy, the number of M&As would be lower, but as you will see, even in 2020, during pandemic times, this number, even not that much, but increased compared to previous years. Besides, these are only numbers, for instance, that the parties need to apply to Competition Board of Turkey. So the real number is way higher than this. We, as the GRATA Istanbul, concluded many M&As this year, I mean, back in 2020, I mean, and which didn't need the approval of Competition Board. So this number of 220 should be multiple, maybe triple times more than the real number. So as you see, only in Turkey, these are some numbers again based on the Competition Board application. And there are some acquisitions by Turks outside Turkey, or companies owned by foreigners in Turkey purchasing companies outside Turkey. These are not included in these numbers. But as you see, the numbers are, when you expect this much of an effect, your economy, the worldwide, but in particular Turkey economy going that down with the numbers I am explained in the beginning, you would not expect that close figures. But as I said, this brought an advantage to those who has cash. For instance, this portfolio management company is a client of GRATA Istanbul. You would see that, in 2000, if you look at the numbers, you can see the increase, like triple times compared to 2022, only in the first quarter of 2021. And if you look at their portfolio back in April 2020, you will see it's only around 600 million TL, but today, only within 4 months, this number increased to 2.5 billion. I put some other examples, for instance, Q-Invest portfolio of Qatar, which also represented by GRATA Istanbul. As you will see, the managed portfolio values increased significantly. That I put these examples to give you an idea, perception of how companies are being invested by these funds. And these funds also regulated and established under Turkish regulations. The funds established outside Turkey can also invest in the Turkish companies, which we would not know, by the way, in these statistics. When it comes to IPOs, as I said, IPOs keeps increasing, again, very significantly. And this is a worldwide trend, by the way. Worldwide, 2020 was the best year for IPOs for the last decade, globally. So the same effect we have here in Turkey due to the need of this cash by the companies. For instance, only 8 IPOs were completed during 2020 value, but now only first quarter we completed 13 IPOs, over 40 expected in 2021. And besides, because now due to high inflation rates, the bank interest, deposit interests are not satisfactory to the individuals. So only in 2022, we have more than 700,000 new investors, local Turkish individual investors. And this is a trend increasing even in 2021. And the final note I would say is the Istanbul Stock Exchange market was the 5th largest in the world in terms of return to their investors. So what I would say, if you look at the general numbers, you can see that there are some problems with the economy, which is understandable. COVID-19 is something that I don't think anybody would have expected. I think we all experiencing history ourselves, but these kind of matters I try to point out here also propose many opportunities for investors. My presentation is basically this. Thank you for listening to me. I hope I could give a perception and idea, understanding of what happened in Turkey in terms of its economy during pandemic times, and I would be happy to answer any questions you have. Thank you.
Many thanks, Ali. That was very comprehensive and describing from various point of view. Many thanks. And our next speaker is Ms. Diana Lupu, who will speak about the main changes to corporate legislation in Moldova. Ms. Lupu, the stage is yours.
Good morning, everyone, and thank you for joining. So just one moment, share my screen. So I will speak about main changes to corporate legislation in Moldova. And the main emphasis will be put on I'm not able to change the slides for some reason. The main emphasis I will put on the law on the joint stock companies. Okay, so I'll do it again.
Diana, if something with the slides don't work, maybe
exactly. I'm not able to change. It's a technical issue. I'm not able to change the slides.
Aria, would you please run the presentation on your screen so that
no, she doesn't have the last.
She does.
She doesn't have the last version. So
I see.
Okay. Well, I did it today, so it should work.
Maybe you can send it to Aria right now.
Yes, I could do that. Okay, it works now. Sorry, it was a technical issue. Okay, so the main emphasis will be put on the Moldovan loan joint stock companies. And the amendment of the law derives from the necessity to comply with the provisions of the Moldova-EU Association Agreement and the National Action Plan for the implementation of this agreement. Also, the purpose of the amended law is to transpose and to make the provision of the law compatible with Euro Community standards. So these are the two main EU directives transposed into the law on joint stock companies. It is the directive of the European Parliament and of the Council relating to, to certain aspects of company law, and directive of European Parliament and of the Council on the exercise of certain rights of shareholders in listed companies. So these are the issues or the items I will cover in this presentation. The main amendments. So this is a brand new article which aims to bring some clarity, considering that in the old version of the law, the notion of the affiliated person was mentioned a number of times without being defined which obviously left space for interpretation. So now the law differentiates two types of affiliated persons, which are persons affiliated with the company and persons affiliated with the natural person. So the list of the shareholders' rights has been slightly extended. Now the shareholders have also the right to ask written questions regarding the items on the agenda of the general meeting. Also the lawmakers have introduced a provision in order to ensure that the company will answer within a maximum of 15 days from the date of receipt of the question addressed by the shareholder. So the old version of the law allowed the shareholders to ask only 2 questions. Now they have unlimited right to ask questions. Okay. And additional to the right to introduce items on the agenda of the annual general meeting of the shareholders who hold at least 5% of the voting shares of the company will be able as well to present draft resolutions for the items included or proposed to be included on the agenda of the general meeting. So for this is the case as well, the right was limited to 2 items only. Now it is unlimited. Also, So the shareholders have the right to include unlimited items on the agenda, provided that each item is justified and a draft resolution for the items included or proposed is submitted. The article also stipulates some procedural rules, including the rule that would exclude the abusive refusal of the board to satisfy a shareholder's request. Okay, so there are new rules regarding the representation of shareholders. It is established the obligation of the representatives to vote at the general meeting based on the instructions of the shareholders only. This could be written or oral instructions. The manner of formalizing the instructions regarding the exercise of the vote by the representative remains exclusively at the discretion of and on the shareholders' own responsibility, while the execution of the given instructions on the representative's responsibility. So the company is not obliged to intervene with the verification procedures of these aspects, except in part aimed at identifying the shareholder or his legal representative. Also, by these amendments, it is excluded the prohibition of a person with position of responsibility within the company to represent a shareholder, but provided that issues concerning a conflict of interest are solved, and only that representation is based on written instructions only. So here is the list of the representatives which are mandatorily required to have written instructions and to inform on a potential conflict of interest. So by introducing new provisions in Article 26, there have been included new rules regarding the repair of the damage made by a representative in case of non-compliance with the voting instructions given by a shareholder. So in order to ensure a higher degree of protection of the shareholders' rights concerning the ownership of the shares within the company, the requirements of the EU provisions are transposed according to which the period of exercise of the preemption right cannot be less than 14 days from the date on which the shareholder actually had the opportunity to know about the share subscription offer. So also the price of shares shall remain remaining unsubscribed after the expiry of the period of exercise of the right of preemption may not be less than the price at which the holders of the preemptive rights subscribed to the shares. So in accordance with the EU provisions which are transposed, new information has to be included in the statutory documents of the company. So, for example, I have one moment. I have highlighted in green the new provisions, so this can be differentiated by the old ones. So the nominal value of the shares, and in the absence, the fixed value of the shares has to be introduced now. Also, not only a list of the expenses for the establishment of the company, but as well an amount or an estimate of those expenses. Also, the data regarding any special advantage granted to the company at the time of incorporation, or to any person who participated in the incorporation of the company. In the charter should be included the classes, the nominal and fixed value, and the number of shares placed, the form and terms of holding the general meeting of shareholders, the value of the non-monetary contributions included in the share capital, the nature of the contributions, and the name of the person making the contribution in question. Also, the report of the valuation company that performed the estimation of the market value of the non-monetary contribution shall be annexed to the company's statute and shall become an integral part of it, including for registration with the state registration body. Regarding the net assets, a new paragraph has been added, and the aim of the paragraph is to quantify the amount of a loss considered significant for a share capital. So if at the end of 3 consecutive financial years, except for the first financial year, the value of the net assets has decreased by more than half of the share capital, according to the latest financial statements, the competent management body of the company is obliged to include the matter in the agenda of the general meeting in order to adopt one of the decision mentioned in paragraph 6. So a decision has to be made regarding the reduction of the share capital, whether the dissolution of the company or the transformation of the company into another legal form of organization. the minimum amount of the capital share also has been changed. It has been increased from 20,000 lei to 6,000 lei, which is approximately 25,000 euros. According to the transitional provisions of the law, the companies will gradually comply with the new requirement within 3 years, I guess, from the date of the entry into force of the law. And the effect of a non-compliance could be the dissolution of the company by judicial act. What concerns the dividends, the amendment clarifies the aspect related to the distribution of intermediate dividends to the shareholders, so as to prove and to ensure as well the sufficiency of the financial means based on the financial statement, which should be prepared for this purpose. Also, this version of the article transposes the EU provision on obliging the shareholders to return illegally distributed dividends to the company. Also, the formula for calculating the amount of dividends that can be distributed to the shareholders is expressly provided. And this is in order to ensure that the distribution is made only within the limit of the registered net profit. Okay, so a new form for holding the general meeting of shareholders has been introduced, which is by electronic means. And the law is supplemented with a new article which sets out exhaustive requirements applicable for holding the general meeting in this way. It is important that the company shall provide the possibility for shareholders to be informed in advance on the form of the conducting of the meeting and to be properly equipped for a possible general meeting by electronic means. So there are a few changes to the articles regarding the acquisition by the company of its own shares. So the company is entitled to acquire the shares placed by it in the a few additional cases, which is as an effect of a judicial act pronounced in a forced execution procedures against the debtor of the company, and as an effect of reorganization by division. So the pledge of its own shares by the company, either directly or through a person acting in its own name, but on behalf of the company, is considered an acquisition that falls under provision of the article. Okay, so the company shall compulsorily acquire the shares placed by it, and a few additional events have been added for this case, which are modification of the main type of activity of the company, the introduction in the company statutes of the provisions regarding the closed transfer of shares, and in the case of the statute provides for the acquisition of its own shares for consideration from minority shareholders or the legal successor who have obtained the shares against government bonds. Okay, so The article regarding the redeemable shares establishes a few new regulations, and the main one is that the redeemable shares are defined precisely as preferred shares issued for a determined period of time, according to the provision of the company's statute. At the same time, the law stipulates now exhaustively the requirements for the issuance of redeemable shares and their method of amortization. So there are also new provisions regarding mergers and dismemberments of the companies. And in accordance with the EU rules, which are being transposed in this article, in the case of mergers, at the same time as the shares are issued and distributed to the shareholders of the newly established company or the absorbing company, a payment of 10% in cash is allowed to shareholders. It is important to mention that in accordance with the Moldovan law, the cash distribution to shareholders can only be made in exceptional cases. The article also has provision regarding the publication of the draft merger contract, as well as exceptional cases when it is not necessary to publish it on the website of the company. And it establishes requirements for the dissemination of information, well, precisely to mention where the draft contract can be consulted. As well, EU provisions are being transposed in this article, according to which is established the obligation to examine the merger contract by independent evaluators, as well as there are detailed requirements for the content of the evaluators' report. The amendments regarding the dismemberment of the company concern the dismemberment project mainly. It is stated what precisely a dismemberment project has to include. Also, the dismemberment project may provide for the issuance of the beneficiary companies of shares for the purpose of their distribution to the shareholders of the divided company, and the payment of a cash payment whose value may not exceed 10% of the nominal value of the shares in the allocated in the beneficiary company. Also, regarding the dismemberment project, it additionally to the provisions established in the civil code, it must contain precise description and distribution of the assets and liabilities to be transferred to each of the beneficiary companies. And for the dismemberment by separation, the assets and liabilities remaining in the company shall be specified. Also, the distribution and precise specification of the number of shares that, as the case may be, are to be allocated by the beneficiary companies to the shareholders of the dismembered company, and of the criteria on the basis of which the distribution is made. Also, this I have mentioned briefly the main amendments to the law. There are also some amendments regarding the quorum of the general meeting of the shareholders. There are also amendments regarding the auditing of the company. But I will stop at this slide. Thank you for your attention.
Many thanks, Diana. That was quite comprehensive. So, dear attenders, do you have any questions? Do you need anything to discuss? Okay, then I have a question, I guess, to all of the speakers, please. So, given those recent changes, it seems to me that this may increase the desire of businesses to go into your jurisdiction, or maybe at some point out of your jurisdiction. Do your jurisdictions provide for any kind of business movement regulation? I mean, moving it from abroad to abroad, like redomicile procedure, or maybe something simpler or more complicated, direct or indirect, or something like that. I think we can start in the order as the speakers presented their presentation. So, Irakli, could you please advise on this?
We have a regulation on reduced domiciling companies in Georgia already for 3, maybe 3-4 years. Yeah, it was existing law was amended based on EU directives here. We also provide possibility. Usually branches in Georgia of local residents needs to be not registered. So we can open branch in any city, in any region, no registration is necessary. But if the foreign company wants to open branch in Georgia, it has to be registered. Registration is necessary. Till now, there was the new law increases workload for a number of list of documents for registration of foreign branch based on again EU requirements. I can just I remember that the balance financial statement has to be presented, even in some cases audited financial statements of mother company or company who wants to register branch in Georgia has to be registered. So, the new law doesn't change anything relating or redomicile of the company.
Okay, yeah, got it. Yeah, so because as far as I can see, this topic is becoming increasingly interesting for businesses worldwide. I mean, the same situation we face in Kazakhstan these days. So, Mr. Chalan, what about you?
Actually, I would say similar things like Irakli. The existing Turkish system, I mean, the regulations are very foreign friendly. And in practice, also, these foreign friendly regulations apply. And there is no difference for a local Turkish citizen and a foreign citizen in terms of doing business in Turkey. And that was one of the main reasons during the last 2 decades in Turkey, because Turkey attracted a lot of foreign investment during these times. I mean, I wouldn't say it's a change, but there is a trend now for foreigners getting Turkish citizenship, which only helps you to, make your life easier, to have your daily life, not business, but daily life, I would say.
I see. And what about the redomicile procedure, this movement of legal entity outside of Turkey or inside of Turkey from other jurisdiction? Is it possible?
I mean, when you say movement of business outside Turkey, is like Turkish companies moving their headquarters to outside Turkey, Maxim?
I mean, just instant movement of a legal entity as it is without a bankruptcy procedure.
No, we don't have that. No.
Like,
no.
oh, I see. Yeah, are there any plans for this? Have you heard of those?
Oh no.
Okay. So, Mr. Pod, do you have any input on this? You're on mute. We don't hear you. Yeah, I see you speaking, but no sound goes. Gentlemen, do you hear Diana? I see it seems to be something with your microphone. So I guess yeah. If any of the participants are interested, we can get back to this by email maybe. Okay. Thank you. So if no other questions here, I think we can finish our webinar. So many thanks. Yep.
Maxim, can I just raise small comments here? I just was listening to excellent presentation made by Diana, and it was fun to see that many similar provisions are proposed in our laws or entrepreneur legislation. Yeah, it's like capital. I see the capital is 25,000 euro, about 25,000 euro. Same in Georgia. We are just adopting this minimum capital for joint stock companies. I see this 10% regulation, publishing requirements of merger and divisions of the company. Membership of the companies. Yeah, it's really fun. It coincides in time and coincides in the substance, but yeah, it's easy to understand why, because we have both obligation under EU association agreement. So yeah, it will be nice to see that Georgian lawyers can somehow understand company provisions in some other countries, except Georgia. It will be nice to have. Yeah, this is one of the benefits of unifying company law, and not only company law, some civil law provisions, commercial law, which will make our profession more universal, more international. Yeah, it was nice result of these initiatives. Thank you.
Yeah, Irakli, just when you spoke, we had a question. Here, I guess it is for you. So would you please have a look at that and maybe give some comments? Yeah, it's in chat.
It's a long question.
I can voice my question if it's okay for you.
Yeah. Yeah, that's really it's good question. Thank you, and
yeah.
it's really it was really problem. This problem was identified by authors of the new law when there was no provision how to regulate deadlocks when shareholders shares are 50% and 50-50. And sometimes this lack of regulation, I would say, was used by not by shareholders acting in bad faith, by blocking any corporate decision, and sometimes company was without directors for prolonged period, and resulting for non-payment of taxes, problem with counter agents, and impossibility to maintain their operation, leading in some extreme cases to insolvency of the company, or to or one of the shareholder was forced to buy out share of another one. So this was one of the reasons why the new law was proposed, and it will be adopted in very soon. In new law deals with such situation, and one of the possible, especially cases where there's a 50-50 distribution and there's a deadlock. In this case, one of the shareholder is authorized to apply to the court for and request dissolution, liquidation of the company. And another shareholder can avoid this dissolution by paying fair value of the share, and this fair value has to be evaluated by the auditor appointed by the judge. So this was somehow some solution, maybe not ideal solution, but this solution is proposed by the new law on entrepreneurs. Have I answered your question?
Yes, thank you very much. There are, of course, other means to avoid this kind of problems, for example, derivative suits against directors. But yeah, without dissolution, this problem somehow must be dealt with, right?
Yeah, actually, yeah, dissolution is the extreme case. It's very, maybe it comes from the Delaware Company Act, where the dissolutions happens when there's a deadlock. Sometimes, not always, but yeah, to buy derivative claims is also possible, but it takes time. Another solution proposed by a law draft is appointing director by the court. Till now, they only appointing member of supervisory council was proposed in the law by the court. The new law draft provides this possibility for director, for CEO. It's not called, by the way, any longer director. They're called members of managerial or administrative body. They can be executive members. All members can be executive members, or some members can be invited members. Yeah. And this, in case the directors, companies without director, any shareholder can apply to the court and appoint a director until the time when the shareholders will agree on proper candidate.
Thank you very much.
Sure, well, no worries.
And I understand Ms. Magradze was interested in answering the same questions from Moldova and Turkish law perspective, right?
That would be also very interesting for me.
Ali, Diana, do you have any input here?
May I leave my answer to after Diana, because I'm sorry, I need to take a call. Just 2 minutes, okay?
Okay.
Diana will answer, I'll get back.
Yeah, sure.
Sorry, I'm sorry.
Diana, I think in the meantime, you may reboot your computer and maybe try to relog. This may help with your microphone problem. Yeah, we didn't hear you anyway.
Just to fill in the pause, going back to Guanza's excellent question. Yeah, there was also a remind that there was practice as a temporary measure. The courts were appointing temporary administrator in the company. It happened a couple of times. Then it was decided by Constitutional Court prohibiting judges to appoint temporary administrator in broadcasting companies. It was some politicized court process ending in Strasbourg court. But in other, except broadcasting companies, courts, parties can apply to the court, and shareholder, one of the shareholder can apply to the court and request appointment of temporary administrator of the company. So this can be solution when the director resigned and shareholders having same share cannot agree on the director or are not willing to agree on director. Thank you.
And as I know, I'm sorry, as I know, under the new law, this provision has been envisaged, right? To appoint director or administration.
Under new law, the new law specially provides possibility to courts
Yes.
to appoint temporary manager.
Yes, that's right. Thank you very much.
May I, Maxim?
Yeah, please proceed.
Of course, we have similar kind of situations like Ms. Magraze mentioned, but generally we have the practice in Turkey is like this. In this kind of situations where deadlock can happen, generally we include in the articles of association of the company how to resolve such deadlock issues. And there is a solution to that in the articles of association, but of course, if the parties are not willing to implement such resolution, then you need to go to court. So generally the courts decide according to the agreement between the shareholders, which first is the articles of association, and second, if there is a separate shareholders agreement between the parties. The problem mostly arises when parties fail to address the issue, address the deadlock issue. Then there are some legal options the shareholders have there. You can ask the court, the party with causing damages to the company with its own actions. You can ask such party to be removed from the company. You can ask the company to be dissolved. You have some various options under different criteria. That's not a general thing applied to all circumstances, but in general, what I can say, the regulations in Turkey address these kind of issues and provides options for the shareholders. The problem I would say here is the length of proceedings. These kind of cases take too much time, and once you're in this kind of situation, and because company is a running entity, a daily living organism kind of, so it really damages the company. Even legally there is a solution to that because of the length of proceedings. One final note, if the company cannot be managed, at least for, as I mentioned, for the daily operations, what you can do, you can ask the court to appoint a trustee to have the company's daily operations, because the damage will be almost irrevocable during the dispute if the company is not managed. So the court may choose to appoint an independent trustee to run the company during this deadlock proceedings.
Thank you very much.
Thank you.
Diana, do you have any input? Does your microphone work now? No, unfortunately not. Still doesn't work. Okay, thank you. Okay, do we have any other questions? Maybe I missed something. It seems to be okay. Thank you, everyone. Thank you, our respectful speakers, for wonderful presentations. That was very comprehensive, very insightful. Thank you, attenders, for visiting our webinar. I hope you found it useful. And should you have any further questions, maybe after this webinar, please feel free to send those by email. We would be glad to assist, to give you some comments on this, etc. So, okay, thank you, and be safe these challenging times. Thank you, everyone.
Thank you, Maxim, for moderating this session.
Thanks.
Thank you all for joining us today.